Hello aspirants and welcome. Today we're diving into a really critical issue for your GS Paper 2 preparation, the Sattankulam custodial death case. That's right. And look, this isn't just about one tragic incident. It's really about the profound questions it raises about the very structure of our entire justice system. So, let's get right into it.
To really get to the heart of this, we've broken down our analysis into 5 key areas, as you can see on your screen. We're going to start with the paradox at the center of the case, walk you through the legal background and the systemic faults, and then we'll wrap up with what matters most for you, the direct relevance for your mains and your interview.
So let's set the stage. On April 6th, the Madurai trial court convicted 9 policemen for the custodial deaths of P. J. Raj and his son, J. Benix. But, the conviction, that was just the beginning of a very serious judicial dilemma.
And this slide really captures that dilemma perfectly. The judge, G. Muthukumaran, was completely torn. The sheer brutality of the crime absolutely demanded a punishment that would fit the rarest of rare doctrine. Exactly. But here's the problem. As a trial court judge, his hands were basically tied by all these legal restrictions on his sentencing powers. He was caught in a real legal paradox.
This quote really gets to the core of it. The judge felt that an ordinary life sentence, with the possibility of release after just 14 years was, and I'm quoting here, derisory for the brutality involved. So he was forced to choose between a sentence he saw as totally inadequate and the finality of the death penalty. He chose the rope.
So the real question is, why? Why was he forced into this all-or-nothing choice? Well, this brings us to a critical flaw in our legal framework, something that legal scholars call the broken ladder of sentencing. And as we're about to see, there's a crucial middle ground that's just missing for our trial court judges.
Just look at the 2 paths laid out here. On one side, you have ordinary life imprisonment. Now, because of remission policies, this could mean release in as little as 14 years. And on the other side, you have the absolute finality of the gallows. There is a huge legal chasm between these 2 sentences, and there's just no bridge for a trial judge to cross.
And this is the missing step. This is the bridge across that chasm, a fixed-term, non-remittable life sentence. That's right. This option lets a court specify a sentence of, let's say, 30 years without any chance of early release. It's the perfect middle ground. But, and this is the key point, this power is simply not available to trial courts like the one in Madurai.
Okay, so why don't trial courts have this power? To answer that, we need to look at some key judicial precedents that have been set by the Supreme Court over the years. Aspirants, you need to pay very close attention here. Understanding this evolution is absolutely crucial for your answers on the functioning of the judiciary.
This timeline is vital. It all starts back in 1980 with the landmark Bachan Singh case, which is what gave us the rarest of rare doctrine for the death penalty. But the real turning point came in 2015 with v. Sriharan. A Constitution bench ruled in a very close 3-2 decision that only high courts and the Supreme Court could impose these fixed-term sentences. And this was just reaffirmed again in 2023 in the Kiran case.
And the legal reasoning here is really the key takeaway for all of you. The Supreme Court majority argued that this wasn't a power that came from the Code of Criminal Procedure, or the CRPC. Instead, it was an inherent constitutional power of the higher courts to do complete justice. This effectively fenced this power off from all the trial courts.
Now you have to understand, this framework wasn't created in a vacuum. The intention was to bring about uniformity, but it has actually led to some pretty significant criticism. That's right. Many legal experts argue that it creates systemic faults and places an unfair and really immense burden on our Sessions Court judges.
Aspirants, please note, these points are absolute gold for a mains answer on judicial reforms. First, it ironically creates non-uniform sentencing because judges are forced into that binary choice we talked about. Secondly, it changes the high court's role from one of simple confirmation to one of primary correction. And third, critical guidelines from the Manoj case on gathering mitigating evidence are often overlooked, which puts a serious strain on the right to a fair trial under Article 21.
And look, this isn't just theoretical stuff. As recently as 2023, in the case of Vasantas Sampa Duparay, the Supreme Court itself expressed concern that the guidelines from the Manoj judgment are being routinely ignored. So this is an ongoing problem that complicates the entire process.
Okay, so let's bring all of this together and connect the dots directly to your UPSC syllabus. This is probably the most important part of our discussion. This is where you translate this understanding directly into marks. So why does this case matter for your preparation?
The Sattankulam case is a perfect contemporary case study for so many key GS Paper 2 topics, like the functioning of the judiciary, separation of powers, and of course, fundamental rights. Exactly. Whenever you're writing an answer on any of these areas, and especially on criminal justice reforms, citing this case and the sentencing paradox will add incredible depth and value to your answer.
So here's a sample mains question that you could realistically face. It's asking you to critically analyze this broken ladder in our jurisprudence. And the structure for your answer is right there in our discussion today. You define the paradox, explain the legal gap with reference to the Sriharan case, and then analyze the systemic faults that we just covered.
And finally, for your interview, be ready for a question like this one. It probes your understanding of the separation of powers. Should Parliament step in and amend the CRPC? It's a really complex question with no easy answer. This case, you see, isn't just about one verdict. It's about the very architecture of justice in India. Think deeply about this. We wish you all the very best in your preparation.